Thank you, Richard. Well, our next speaker is a gentleman who has done the work of freedom in a different way. He has helped dozens of people across the country in their own individual battles against not only the IRS, but only corrupt sheriffs, corrupt towing companies, corrupt companies, like big companies, like United Airlines, who unlawfully take your paycheck and throw it away to the IRS, from unscrupulous people who try to take advantage of IRS taking away your property. This gentleman has been so creative in giving us new tools and new methods of combating government corruption. And he's made it easy. We're proud to have this gentleman also be one of the teachers at Freedom Law School. We were so impressed with the work that he's done and the work he's going to tell you about, folks. Although he won't have the time to show it all to you, but I tell you, I got the proof of the stuff he talks about. He's got it with him. We've had him twice come from New Mexico to California to conduct 2 of our courses. Beat the IRS now and get your Social Security off government computers now. And he's really one of the most creative people on the cutting edge of liberation technology. So he might not be quite as rousing as Richard was in his delivery, but I want you to know his message is just as powerful. So please help me give a warm hand of welcome to our next speaker, Mr. David Wellington.
Before I get started, got one thing I want to say. What's up? You guys believe those guys went off with that? Got the big Budweiser deal now? 16 years ago they started that stuff. And I went on a Jay Leno show, went over to a bowling alley and asked these 50 and 60-year-old women to try to do that. It's real funny. Got a letter that somebody wrote to the Secretary of Agriculture. It says, "Dear sir, my friend Ed Peterson over in Wells, Iowa received a check for $1,000 from the government for not raising hogs. So I want to go into the not raising hogs business next year. What I want to know is, in your opinion, what is the best kind of farm not to raise hogs on? What is the best breed of hogs not to raise? I want to be sure I approach this endeavor in keeping with all government policies. I would prefer not to raise Razorbacks, but if that's not a good breed not to raise, then I will just as gladly not raise Yorkshires or Durocs. As I see it, the hardest part of this program will be in keeping an accurate inventory of how many hogs I haven't raised." My friend Peterson is very joyful about the future of the business. He has been raising hogs for 20 years or so, and the best he ever made on them was $422 in 1968. Until this year, when he got your check for $1,000 for not raising hogs. If I get $1,000 for not raising 50 hogs, will I get 2,000 for not raising 100? I plan to operate on a small scale at first, holding myself down to about 4,000 hogs not raised, which will mean about 80,000 the first year. Then I could afford an airplane. Now, another thing, these hogs I will not raise will not eat 100,000 bushels of corn. I understand you also pay farmers for not raising corn or wheat. Will I qualify for payments for not raising wheat and corn, not to feed these 4,000 hogs I'm not going to raise? Also, I'm considering the not milking cows business. So send me information you have on that too. In view of these circumstances, you understand that I will be totally unemployed and plan to file for unemployment and food stamps. Be assured you will have my vote the next election. Politically yours, Dogbite. P.S. Would you please notify me when you plan to distribute more free cheese? Has everyone here heard of the IRS? No? I saw a big sign over there, but I don't think that's quite right. Actually, the initials stand for Instant Robbery Squad. I don't know if you noticed it or not, the IRS has been taking a real beating in the last couple of years.
Yeah.
97 and 98, both the House and the Senate held hearings on IRS abuse. 98, Congress passed a whole new slew of laws to protect us from this agency that's just drunk with power and out of control. I think one of the most devastating of those new laws is the one that allows the firing of IRS agents for doing certain things. According to an article in USA Today in February, IRS seizures in '99 dropped 98%. I don't know if that has anything to do with that new law that puts these IRS agents' job on the line. But I think that can be interpreted in one of two ways. Either these agents knew all along that what they were doing was illegal or wrong, and now they don't want to put their job on the line. And now they're throwing a tantrum. Here's the other way to look at it. The IRS saying to the Congress, well, if you won't let us terrorize people, we're not going to collect. And you'll be sorry, Congress. One problem, though. Although seizures dropped 98%, the revenue from enforced collection only dropped 13%. Which leads to another question. With that kind of ratio, how effective really are seizures? 98% drop, only 13% drop in revenue. Congress may have to look at that too. But this IRS abuse, I don't know how long it will take to go away, because according to the Congress itself and its own findings, and Senator Roth, who was the chairman of the committee that held one of the hearings, found out that this mentality of the IRS is ingrained. It's like a culture. It won't go away easily, but because of that, those may be the very seeds of the IRS's destruction. Because if they continue in abusing people like they have been, I don't think Congress is going to put up with it. You know, things are a whole lot different than they were about 20 years ago. Back then, one of the big issues was the money argument. You guys all heard of that? For those of you who might not be familiar with it, in a nutshell, these pieces of paper that we carry around in our wallets, we call them dollars, but they're not really dollars. These things are masquerading as dollars. About 3 weeks ago, got this from Coin Shop. It's a Morgan dollar. Now it took 8.5 of these to get one of these? They both say dollar right on them. Now, I was afflicted with public school just like the rest of you were. But I don't even think public school could justify saying that this is $1, but it takes 8.5 of these to get one of these, when it says it's $1. Somebody's lying somewhere. But anyway, the argument went, as far as tax purposes, since all I got was these for pay, I didn't receive any dollars. So, what do they ask for on your tax returns? As far as figures, how many dollars? So the argument went, well, since I didn't receive any dollars, income was 0. And that led to people saying, okay, well, if I don't have any dollars coming in and the income tax is based on dollars, stop withholding. And a lot of people went in and filed W-4 exempts. And by the way, since I didn't have any dollars for prior years either, give me a refund of everything I paid you. Now, there was some constitutional support for the argument. Constitution says in Article 1, Section 10, no state shall make anything but gold and silver coin tendered payment of debt. Does this look like gold or silver coin to anybody? Now think about this a second. If you dealt in these instead of these, and it takes 1/8 the amount of these to do the same thing that these will do, what would that do to your tax situation? Let's take an example. Let's say that someone's making 32,000 of these a year. But if they dealt in these, they'd only need 1/8 of that amount, 4,000. How many of you would be filing tax returns on $4,000 a year? Now, this problem about this paper money system was so well known back in the 1980s, in the early 80s, that they even developed a phrase for this thing where you have to keep getting more and more paper to get the same goods and services as far as taxes were concerned. Anybody remember what the phrase was? Bracket creep. That's exactly right. Bracket creep. Where you have to get paid more money just to buy the same goods and services, but it kicks you up into a higher tax bracket. While we're on the subject of money, I'd like to read you a statute from the United States Code, a portion of it, that deals with these pieces of paper that we carry around. This is out of Title 12, Section 411. It says Federal Reserve notes shall be obligations of the United States. That means they're debts. By federal law, these things are debts. It also says they shall be redeemed in lawful money on demand at the Treasury Department or any Federal Reserve Bank. Well, what's lawful money? Gold and silver coin. That raises another interesting question. If our money system is based on debt and the money is loaned to us at interest, how in the world is it ever going to get paid off? It's impossible. Another question is, if the United States claims to be a sovereign, why doesn't it issue its own currency instead of borrowing it from the Federal Reserve Bank? Back in the 1940s, there was a gentleman who gave a speech that was entitled "Taxes for Revenue Are Obsolete." Now, this guy must have been some wild-eyed, rabble-rousing, commie pinko, foaming at the mouth tax protester, right? His name was Beardsley Rummel. He was chairman of the New York Federal Reserve Bank. Who did he give the speech to? The American Bar Association. In his speech, he explains what taxes are actually for. I'd like to read a portion of it to you. It says, the necessity for a government to tax in order to maintain both its independence and its solvency is true for state and local governments, but it is not true for a national government. Two changes of the greatest consequence have occurred in the last 25 years, which have substantially altered the position of the national state with respect to the financing of its current requirements. The first of these changes is the gaining of vast new experience in the management of central banks. The second change is the elimination, for domestic purposes, of the convertibility of currency into gold. Final freedom from the domestic money market exists for every sovereign national state where an institution which functions in the manner of a modern central bank and whose currency is not convertible into gold or into some other commodity. The United States is a national state which has a central banking system, the Federal Reserve, and whose currency for domestic purposes is not convertible into any commodity. It follows that our federal government has final freedom from the money market in meeting its financial requirements. Accordingly, the inevitable social and economic consequences of any and all taxes have now become the prime consideration in the imposition of taxes. In general, it may be said that since all taxes have consequences of social and economic character, the government should look to these consequences in formulating its tax policy. All federal taxes must meet the test of public policy and practical effect. The public purpose which is served should never be obscured in a tax program under the mask of raising revenue. What taxes are really for? Number one, as an instrument of fiscal policy to help stabilize the purchasing power of the dollar. What they do is they take the money out of circulation through taxation to control inflation. Because if they didn't do that, it would become so exposed and so well understood, the money system would have to fall on its face. Number two is to express public policy in the distribution of wealth and income, as in the case of progressive income and estate taxes. Not raising revenue, redistributing property. Number three, to express public policy in subsidizing or penalizing various industries and economic groups. Again, not raising revenue, social controls. Final thing is to isolate and assess directly the cost of certain national benefits such as highways and Social Security. So what it boils down to is income tax is not about raising revenue. It's about controls. It's about social engineering. Is Congress aware of this? This is from the U.S. Code Congressional Administrative News from 1982. This is from a tax committee. The committee believes that the current system of income tax is unduly complex. The large number of tax preferences, special deductions, credits, and exclusions increase compliance and administration costs and undermine the taxpayer's confidence in the fairness of the Internal Revenue Code. Non-uniform taxation distorts individual and corporate economic decisions, thereby lowering economic efficiency. For these reasons, it is desirable to study the effects of a more comprehensive tax base, broadening the base also would allow a reduction in marginal rates, which would increase the incentive to work and invest. The committee believes that alternatives which increase the simplicity, efficiency, and fairness of the tax system should be carefully studied. The bill requires the Secretary of the Treasury to conduct a study of the advisability of replacing, 1, only the federal individual income tax, 2, both the federal individual and corporate tax, with an alternative tax system. For this purpose, an alternative tax system means a system based on 1, a simplified income tax based on gross income, 2, a consumption tax, 3, a percentage tax on consumption, or 4, the broadening of the base and lowering of the rates of different current income tax. The study is to consider the administrative complexity of the existing federal income tax system and to address the ramifications of replacing the existing system with an alternative system. This is 1982. Congress is well aware of what's going on. They're well aware that income tax is not about raising revenue, but control. And it's control from the bedroom to the boardroom, what I call it. You all probably seen the commercial, I think it's by H&R Block, where the woman announces she's pregnant, and the man says, "Great, honey, another baby, another deduction." We have some serious problems with the income tax at a very fundamental level. In the mid to late 80s, Bill Benson and Red Beckman went to the archives of each and every state in the Union and conclusively proved the 16th Amendment to the Constitution, the Income Tax Amendment, was never actually ratified. You heard some speakers yesterday talk about that. They published their findings in a set of books called The Law That Never Was. Volume 1 and 2, they're on the, some people have them on the back tables there. After they put the book together, Bill sent copies in hardback with the names of each member of the Senate, Congress, and federal judges, with their names engraved on the cover. Of the few that responded, the legislators said, well, it's an issue for the courts. Went to the courts. The courts said, oh, it's an issue for the legislature. One decision went as far as to say they wouldn't rule on the issue because they wouldn't want to embarrass another branch of government. Some others said, well, it's been around for so long, we'll just grandfather it in. No one's ever contradicted those findings. As you heard yesterday, there was a sitting senator who approached Bill to buy all his books and his rights to sell them. Bill declined that offer. Yet the government still claims we have this highly questionable tax system. Later on, in the late 80s, we found out that the IRS was having a little problem with several federal acts. One of them called the Administrative Procedures Act, the other one called the Paperwork Reduction Act. Now, this is important because the government says they want you to file a return. Okay, well, what's that? Most people think it's a 1040 form. Where do they get that idea from? You can go through the entire revenue code and you will not find any definition for the word return. Unbelievable as that might be, and as much importance as the government puts on this particular item, it's not defined anywhere. The only place you're going to find it is in regulations. Now, the Administrative Procedures Act applies to this because the IRS had not, it requires federal agencies to publish in the Federal Register any forms, any regulations, the publications that demand information from the public. The IRS hadn't done that. Back in 1980, Congress passed what's called the Paperwork Reduction Act. And they wanted to put federal agencies on a paper diet, reduce the paperwork burdens on the public. And what that required was that every federal agency who had any form, any regulation, any instructions that demanded any information from the general public had to go to the Office of Management and Budget and get approved. Once they got the approval, if they got the approval, OMB would assign them what's called an OMB control number. And these numbers had to be put on the forms, the regulations, and the instruction books. IRS hadn't complied with that either. Now, both these acts said that the agency's failure to comply could not result in any penalty being imposed on the public. So this issue went to court as it applied to the tax arena. Judge saw the problem. One district court judge said, well, I'm not going to be the one to overturn the apple cart. In order to get around these violations of the law by the IRS, your federal Ninth Circuit Court of Appeals went so far as to say, well, you're still required to file a return. You don't have to use a 1040 form. Did you guys hear that on the news? No. You guys didn't hear anything about that. Now, the Ninth Circuit said that you're not required to file a 1040 form in order to file a return. What they did say was that you can sit down with the code, and Steve showed you a volume of that yesterday. It's about that thick. That's only half of it. That's volume 1. Sit down with that and the regulations, which are about 4 more volumes. And after you get done reading all that and applying your situation to it, you can make out a return. Then I can tell you what it is, but you're not excused from making one. Another issue that's just come up recently, we found out that Congress never created the IRS. There's no statute that ever created the Internal Revenue Service. I don't know where that issue might go, but in view of what we're seeing from the courts already, they're going to find some way to twist and squirm and contort themselves in whatever manner they need to preserve the system. This last issue has been found out by Attorney Larry Beecraft, and if you haven't seen his website yet, I highly recommend you go to it. It's networkusa.org, O-R-G. And on that site, you'll find a lot of arguments that have already been presented that have failed. So if you think you have one, go check out the website and see if somebody's already argued it, where it went. But it's a great research site. He's already got stuff together that you can probably put into a brief that you might be working on. So check out the site, networkusa.org. So we have the problem with the money that applies to the tax situation. We have the problem with the violations of the Administrative Procedures Act, violations of the Paperwork Reduction Act. Congress was never even created the IRS. With all these serious fundamental problems, the government still forces a system down your throat. What do you have? I call it a grand scheme of nothing but extortion. And I think what we have on our hands is a war. War started by the judicial system on the Constitution. These judges have no integrity, no honesty. And since we have a situation where the judges will make no decision that will seriously affect the system, then we need to use some tactics and strategies. Because the IRS is still going to come knocking and want you to file and pay, and if you don't, they want to come and steal your property. That leads to some interesting situations. One case started back in 1989, one by the name of Patricia Farr, lives up in Idaho. And she worked for United Airlines. United had received a levy notice from IRS. They could not give away her money fast enough. Started shoveling it out to them. But see, there's one thing. She was on receiving workers' compensation. United Airlines administers its own workers' comp program. But workers' compensation is statutorily exempt from levy. They were giving it away anyway. And we looked at that situation, and we couldn't decide who was responsible, IRS or United Airlines. There were no cases about who was responsible for that prior to that. So what she did is she sued the United States and United Airlines both. And alleged against United Airlines that what they were doing was illegal by giving away statutorily exempt property. She filed suit. United went out and got one of the biggest attorney firms, at least in the western side of this country, Wellington and Myers. Some of you may have heard of them. And they made their argument that they were immune from suit. And the judge of the district court dismissed the case on the grounds that, oh, well, they're immune from suit because they're immune because they're doing just regular withholding. It's got nothing to do with a levy. But nobody ever said you had to be very smart to be a federal judge, I guess. Case went up on appeal. And the Ninth Circuit issued a published decision that said, you know you're not immune, United Airlines, because the property you were giving away was statutorily exempt from levy. Now, one of the problems that United started crying about was that the levy notice didn't specify what United should be giving to them. All it does is make a general statement saying, give us everything except what's exempt. And United actually asked for a rehearing after the appellate court made its decision, crying about, well, we don't want to be responsible for making that decision. Appellate court didn't hear it. Case went back down to district court. As it progressed through, it was coming down to the wire as far as a trial. All of a sudden, Patty starts getting calls from the attorneys for United wanting to talk about settlement. And she ended up settling the case for about 3 times what we figured what they had owed her. In another case, this happened out in New Mexico. October 96, the IRS, tow company, and 2 sheriff's deputies came out, started towing cars away from a man by the name of Elmer Gonzalez. He goes by Double E. Elmer came out to find out what all the ruckus was about. This happened in the morning. He approached the sheriff's deputies and said, you know, what's going on here? He said, IRS is taking your cars. He asked the sheriff's deputies, well, show me the paperwork. I said, oh, they got it over there. They didn't have anything. So we took a look at that situation and looked at the revenue code. Couldn't find any place where it said the IRS could either contract or delegate its seizure authority to any private parties. Couldn't find anywhere in there where it said that local police have anything to do with IRS seizures. So we decided to throw a party. This party costs $150 and it's held in federal district court. $150 is your filing fee. Now when you throw a party, of course, you have to figure out who you want to invite. The invitations that we have are called summonses. And we decided that we wanted just to invite the towing company and the cops. Leave the IRS out. And the complaint read something like this. One morning on October 1996, 2 sheriff deputies and tow company came out and started towing my cars away in violation of my 4th and 5th Amendment rights. We want $1 million in damages. We had an interesting response to that. Although the Sheriff's Department just filed an answer to the complaint, the towing company decided that, well, if we're going to be liable, we want the United States to be liable too. So they filed a third-party cross-claim against the United States. And in their cross-claim, they even alleged, well, we asked IRS to come help us and they won't. Only one problem, though. There's this thing called sovereign immunity. Basically what that is you cannot sue the United States unless there's a statute that allows it for the particular circumstance. There was no statute that allowed the United States to be sued by a towing company in these circumstances. When the United States filed its answer, it alleged that in its answer to the complaint. You don't have jurisdiction over us, court. We haven't waived sovereign immunity. You should dismiss the case. But it was an interesting response because usually in those circumstances when the government has a sovereign immunity claim, they'll file a motion to dismiss, which is routinely granted by the district courts. They didn't do that in this case, though. Another interesting thing that happened was at the time that the complaint was filed, there was a scheduling order issued. It's pretty routine in cases. That scheduling order has to be served on the parties that are existing at the time that it's issued. The United States wasn't a party at that time. So they were never notified of this scheduling date. But nonetheless, when it arrived, in walked none other than the U.S. Attorney. Now, let me ask you this. What is a U.S. Attorney coming to a conference for where he is alleging that the court has no jurisdiction and the case should be dismissed? Why is he wasting his time doing that? The answer was he really wasn't there to defend the United States. He was there to try to help the towing company and maybe the cops. That case ended up also getting settled. and Double E got several $1,000s for the cars that were towed away from the towing company and from the police department. Also ended up that the two sheriff's deputies who went out to the scene ended up quitting. So what's the end result of that? We got money collected for damages, a towing company that's probably not going to ever help IRS again, and two sheriff deputies who will never help IRS again because they're not even sheriff deputies anymore. It's another interesting case. This was one out here in California by a guy who was getting a pension from the California Field Ironworkers Trust Fund. And he was getting his retirement pension. IRS sent a levy notice out to the trust fund. Send us his money. Now, one of the things about IRS levy notices is there are two ways they work. They work on wages and they work on other different kinds of payments in different ways. Code says if it's a wage levy, it's continuous. But if it's not a wage levy, it's not continuous. What was happening was the trust fund was sending this guy's pension, which was a month-to-month payment. Not only were they sending it continuously to IRS, but they were ignoring the required exemptions. So when you're in a levy situation, there is a minimum amount that's statutorily exempt from levy. They were ignoring that too. This guy brought a suit through another party. And within 3 days of being served the summons and complaint, the trust fund had express mailed several of his checks over to him. We had never seen such results so fast. Because before that, they were saying, he had been writing letters to them saying, and their response was, oh, well, we sent the money to IRS. You have to take it up with them. He even got the National Workers' Rights Committee to write a letter on his behalf about this issue. Same response. Yet there was a letter enclosed with the overnight package that said, we inadvertently sent your checks to IRS. Now all these different kinds of ways of approaching are entertaining to say the least. But I want to spend my last few minutes up here talking about a different kind of strategy for dealing with this, and that's called the no liability return. And what this does is it sets you up in a situation where you can be entitled to a refund of everything that the IRS may have collected for the entire year. Now you heard Bill up here yesterday talking about you shouldn't claim exemption from withholding or screw around with that too much. I agree. So you're not going to change withholding in this procedure. You're not going to change the way you file a return in this procedure. This is basically for people who might have been sitting on the sidelines thinking, oh, this non-filing, non-paying is too risky, I don't want to do that. This is something you can do. The only change you're going to make is you attach a letter to your return which disclaims any liability for any amount shown on that return. You fill out the return the regular way that anybody would normally do. But when you put that disclaimer of liability on there, what it does legally changes the amount that you claim to be owed to zero. Now, the IRS has your money, and they got it through withholding or estimated payments, whatever way they got it. But in order to keep that money, they have to make an assessment. If they don't make the assessment, they can't keep the money. If they make an illegal assessment, they can't keep the money. How many of you have written to IRS and asked for a copy of your assessment records for any year? Anybody? A couple people? Recommend you do that. Simple letter, could be 2 sentences. All you're going to do is say, pursuant to section 6203 of the Revenue Code, I want my assessment records for whatever you want them for. They're required to send them to you. But when you do this no liability return thing, they're prohibited from assessing, and it technically creates what's called a deficiency situation. But in all probability, they will not issue a notice of deficiency, even though it's required. But if they don't do it, any assessment they make will be illegal, subject to refund. There was a company that went through this, not this exact procedure, where the IRS made an illegal assessment without sending a notice of deficiency when it was required. And because of that, the court ordered a $10 million refund. Violation of that one procedure. What's the chance of the IRS issuing that required deficiency notice in this kind of situation? Well, let's look at a case that I personally know about, where the IRS was issued an injunction by the court to stop collection activity against these people until they issued the notice of deficiency. And this was in July of '98. People had filed in December '95 for the year '94. Okay, we all know that the IRS has 3 years to make a legal valid assessment. In this case, the court said, no more collection until you issue the deficiency notice. Since they filed in December '95, IRS had till December '98 to issue the notice of deficiency. What do you think they did? Even after being told by a court, issue the notice of deficiency or stop collection, they still did not do it. These guys are dense. How much time do I have left? Okay. 5 minutes? Okay. Anyway, what I did is I put together a publication on that approach. It's called No Liability Return. And it's based on 80 years of the courts saying the same thing. It's based on such mainstream authorities as Ira Saltzman, who writes a book about yay thick in hardback you can find in most law libraries in the tax section. Ira Saltzman used to work for IRS, and he's considered a mainstream authority on practice and procedure. It's based on such things as American jurisprudence. It says the same thing.
What's the name of the book?
No Liability Return.
Is that on sale here? Or?
Yes, it's at the back table over there. But these all say that this is the way, or at least one way, to challenge the system. And it sets you up in a position where you're really taking no risk. Okay? Because if you do this, what's the risk of you getting prosecuted for failure to file? Zero. They got the return. What's the risk of them coming after you for more money? They got the money already. Got it through withholding. So you're back there in the driver's seat. Your decision as to what you want to do. But it takes the risk out of the entire procedure, and in most cases, the IRS will not follow procedure and put you in the position that you're entitled to a refund of everything that they may have withheld or that you paid in estimated tax. So this is something that people hear for the first time may want to look at, or people who think that the non-filing, non-paying position is too risky or not for them. Because I think we're at a point where the IRS might be on its way out. We've got Congress against them, making laws that they're basically throwing a tantrum about, saying we don't want to take the risk of having our being fired from our job. So seizures are down 98%. Criminal prosecutions are down the same amount last year. And we're not sure what the IRS is going to do in the future, but if we can get more people to pile on to get this tax system gone and take no risk in doing it, I think that's a good thing to do. Thank you for your time.